beep, beep. How are we all doing today? Hey, here we go. Now, Suella Braverman. Braverman, that's her name, isn't it? Suella DeVille. She's been a warbling in the Telegraph. So I've got something interesting for you this morning. Whoa! This will upset a few people, including people on our side of this particular bloody scrap, right? So we've had a few wins. That can't be undone, can it now? Supreme Court ruling and all that? Why, yeah, well, these bloody trans-supporting businesses must be quaking in their Wellington boots. At least one hopes that they are. But the madness continues. And I posted on Twitter yesterday, this ain't going to end till we end EDI/DEI. It's true. Until we end that, none of this is going to change. You think it is, but it isn't. It's that simple. It's like somebody said to me yesterday when I was out for the, not yesterday, day before, for a luncheon. You can change the law, but without enforcement, you're wasting your time. And this is true. So we're going to have to see what happens. And the enforcement is down to us. So if you see a LARPing bloke or a woman using a toilet they shouldn't be using, say something. If you've got a workplace that is forcing people to use pronouns, say so. It's up to us now. It's now time to speak up. And I think with the passing of the Supreme Court that people are becoming braver. I do hope so, particularly gay men. Bunch of puffs. So they'll get a bit braver now and we'll be away. But until then, Suella Braverman has provided us with something to discuss today. And I'm looking forward to seeing what you have to say in the Dubris, as per the usuals, right? So here we go. We must abolish the Equality Act. That will send some of our side scarpering to their leftist corner, won't it? Yes, Suella, we do have to abolish the Equality Act. Individual worth needs to come before group identity. This is the best foundation for justice. One thing became unmistakably clear, says Suella. After the Supreme Court's recent judgment, Britain's equality laws have long been confusing and dangerously open to misinterpretation and exploitation. Instead of protecting individuals from unfair treatment, the legal framework has been weaponized. Never a truer word spoken, Suella. It has been weaponized. People, different rights groups. No. It's all nonsense, as you'll see as we unfold this article from Braverman. Lawyers now lead rival groups into battle under its banners, each armed with their preferred interpretation of rights. We have lost count of the trans women, that is, biological men, claiming the right to enter women-only spaces, from changing rooms to hospital wards, citing protections under the Equality Act. Sport, too, has not been spared. From football pitch lineups to London Marathon, biological men claiming to be women have lined up against female competitors. Oh, so far so good. Don't you think this is true? This is exactly what's been happening. These LARPing men, intruding, as men do, and trying to get their men's rights activist work done by taking over women's spaces. Meanwhile, here's a good one. Employees who express the apparently controversial view that a man that cannot become a woman have faced dismissal and litigation. Across workplaces, courts and classrooms, Britain's common sense is on trial. And it is losing. It is often said that the Equality Act is a shield, not a sword, a remedy for those who have suffered injustice. Those fighting to protect women-only spaces even invoke the Equality Act. But today, the Act is more often wielded as a rapier. It has fueled the rise of a new cult, that of diversity, equity, and inclusion. Well bloody said, where box ticking and group identity have supplanted ability and character. This is why on the Warrior Teacher Programme, which you can still sign up for, on the Warrior Teacher Programme, come and join us, let me know, message me, right? On the Warrior Teacher Programme, we talk about might, meritocracy, intelligence, talent, and excellence. That's the game, right? The rest of it goes. When Gordon Brown passed the Equality Act in 2010, it was hailed as a landmark moment, a great codification of 116 separate pieces of anti-discrimination legislation into one accessible whole. No Conservative Prime Minister, despite grumbling in government, dared reform it. That failure of nerve is a source of regret. The Act echoed, and in many cases exceeded, European Union law. It created 9 protected characteristics ranging from disability and gender reassignment to religion and sexual orientation to supposedly ensure fairness. That's not what it's done. But from its inception, the Act contained a fatal flaw. It elevated group identity over individual equality before the law. At last, somebody says it. Elevated group identity. That's so lefty, isn't it? Collectivism. It elevated group identity over individual equality before the law, rather than treating all citizens equally as individual British subjects, a principle at the very heart of our common law tradition. Here's the interesting thing, you see. DEI, all the crap that comes with it, the Equality Act, is actually not in tune with our law at all. Common law tradition in the UK is that the individual is sacrosanct and paramount. It carved up the population into competing tribes, and we've seen the tribal behaviour that comes from that. It also legitimised discrimination in the name of positive action. Sections 158 and 159 of the Act allow employers to prefer candidates from underrepresented groups. The RAF, British intelligence agencies, NHS and several police forces have prioritised minority recruits at the expense of white, straight men. The Equality Act was designed to protect us against discrimination. It has instead institutionalised new forms of it. This is so true. This is so true. I've said this before, that, we cannot have positive discrimination. It has to go. It all ends. All of it. You don't elevate anybody above anybody else, because then you're heading for an attempt to create equity, which is equality of outcome. People die then, in case you haven't noticed. That's what happens. I will do this. It's such a good idea. It's so kind. And then, so many years later, the bodies pile up. That's because equity is murderous. It has also been a source of uncertainty. Now, again, this particular area is very clear that there is a collision between the Equality Act and the Gender Recognition Act, which has created fertile ground for endless litigation. What should have been simple, the meaning of sex, has been left legally ambiguous for the best part of a decade. Well, we need to get rid of the GRA next, don't we? That needs to go, and along with the Equality Act. And while the Supreme Court judgment has restored some clarity to women-only spaces, many questions remain. What of trans men, biological women? Will they retain access to women's facilities? Will they be permitted to conduct strip searches or intimate medical procedures on biological women? When even a unanimous Supreme Court ruling cannot fully resolve the uncertainty, the law itself is the problem. Oh, this is such a good article. She's very clear. You might not like her. You might not agree with what she says, but she's very clear. And lastly, the Equality Act has given birth to an entire bureaucracy dedicated to enforcing DEI orthodoxy. The Public Sector Equality Duty, or PSED, imposed under Section 149, has become a millstone around the necks of public bodies, requiring them to demonstrate due regard to fostering good relations and advancing equality. Now, interestingly, what Suella doesn't mention here, so I will, is that what happens then is if you want to work for the public sector, they pass that nonsense down. So it's even affecting the private sector. It all goes. This is an unmeasurable and costly burden. Ministers and civil servants live in fear of legal challenge, so they overcompensate. The civil service's diversity champions and the Sentencing Council's guidelines are symptoms of this pathology. I mean, this is where we've seen it in the formation of these affinity groups for various reasons, and then they want supremacy, and they want to be able to. They become what's called a stakeholder. If you hear that term run, well, I'm talking to the stakeholders. So if you're talking to your stakeholders, you're an idiot, right? So the private sector has followed, with HR officers and becoming DEI crusaders. Unconscious bias training is standard, and identity politics is entrenched in much of corporate Britain. What then is to be done? Asks Suella. Many conservatives have railed against political correctness. Few have seriously grappled with how deeply the problem is embedded in law itself. Britain's equalitist framework, designed to empower minorities and prevent injustice, achieves some of its aims. Today, Britain is indeed more tolerant and diverse, but at an enormous cost. Instead of equality, we have reverse discrimination. Instead of clarity, we have legal chaos. Instead of inclusion, we have exclusion. This time directed at the wrong sex, race, or political opinion. The Equality Act has outlived its usefulness, damaged our national fabric, and must be repealed. Britain must return to a nobler and simpler principle, that every citizen is equal before the law, not because of their group identity, but because of their individual worth. Well, I don't know about you, but I, for one, am with Suella, and I look forward to hearing what you've got to say as to whether or not you are with Suella as well. It's time it ended. That's the best words about the Equality Act I've heard in a long time. I'll see you later, folks. Bye-bye.